Sit tight for me, okay? 4 words. Sounds like a favor. In Canada, it's usually the sound of your charter rights getting quietly put on hold. Today, I'm giving you the 9 words that switch them back on. And by the end of this video, you'll understand something most Canadian drivers go their whole lives without ever learning. Every police stop in this country runs on an invisible timer, even though nobody ever hands you a stopwatch to check it against. Here's the scene. You've been pulled over for 10 minutes. The officer walks back to your window, hands you your license, your registration, maybe a ticket, maybe just a warning. The paperwork is done. The reason for the stop is finished. Then, almost as an afterthought, tossed over his shoulder as he starts to walk away, he says it. "Sit tight for me, okay?" And he heads back toward his cruiser. What just happened there? Was that a request? An order? Something in between? To understand it properly, you need to know about the case that quietly governs every single police stop in this country, and I promise the story is worth your time. Rewind a couple of decades. Late at night, in a residential neighborhood in Winnipeg, police get a report of a break-and-enter nearby. The description they're given is thin, almost nothing to go on. Young, black male, dark clothing. That's essentially the whole tip. A short while later, 2 officers spot a man walking down the street who loosely fits that description. Nothing else connects him to the break-in. No stolen property in sight, no matching behavior, nothing beyond a vague resemblance to a vague description. They stop him anyway. For officer safety, they say, they pat him down. In his front pocket, they find a small bag of marijuana. They keep searching. In another pocket, they find more, enough that the Crown argues it points to trafficking. He's arrested and charged. This case eventually reaches the Supreme Court of Canada, and it becomes one of the most cited decisions in Canadian policing law. The Crown's position is straightforward. Police need room to act on instinct and experience to keep communities safe. The officers had a general description. It was late at night. The neighborhood had just had a break-in reported. Isn't that a reasonable basis to stop and check someone? The Supreme Court says, not even close. In 2004, in R.V. Mann, the court draws a line that still shapes every roadside interaction in Canada today. Police are allowed to detain someone for investigative purposes, but only when they have what the law calls reasonable suspicion. A constellation of objectively discernible facts, specific, articulable, and connected to a particular offense. Not just a feeling, not just a hunch, not just a vague resemblance in a nervous moment. A generic description matched loosely in a high-crime area, on its own, does not meet that bar. The detention was unlawful. Everything that flowed from it, the search, the evidence, was thrown out as a result. Reasonable suspicion. Hold on to that phrase, because the entire system pivots on it. Section 9 of the Canadian Charter of Rights and Freedoms guarantees you the right not to be arbitrarily detained. Not detained whenever it's convenient for an officer. Not detained because it's a slow shift and something feels off. Arbitrary means without lawful justification. Full stop. And the Supreme Court has repeated this principle in case after case since, including in R.V. Lee in 2019, where the court reaffirmed that Section 9 exists specifically to protect individual liberty and to protect your right to simply decide for yourself whether you want to keep talking to a police officer or walk or drive away. Now, you might be thinking, fine, but a traffic stop is different from a guy walking down a sidewalk. And you'd be partly right. Random stops for genuinely traffic-related reasons, checking a license, checking insurance, checking sobriety, checking the mechanical condition of the vehicle, are treated differently under the law. In a case called R.V. Ladouceur back in 1990, the Supreme Court acknowledged that random highway stops are technically a violation of Section 9. They are arbitrary in the strict legal sense because officers have broad discretion over who to stop. But the court ruled that this particular violation is justified under Section 1 of the Charter, the section that allows reasonable limits on rights when they serve a pressing public purpose, in this case, highway safety. So yes, an officer absolutely can pull you over for no specific reason at all, just to check your paperwork and your sobriety. That part is settled law in this country, and arguing about it on the roadside gets you nowhere. But here's the part that almost nobody understands, and it's the entire point of this video. That justification is narrow. It covers exactly what it says it covers: checking your license, checking your insurance, checking your sobriety, checking your vehicle. The moment that specific purpose is finished, the justification runs out with it. The stop is supposed to end. Anything after that point needs its own separate justification, either genuine new reasonable suspicion under the Mann standard, connected to an actual offense, or your own free and voluntary consent to keep talking. So why does sit tight for me, okay, keep working night after night on roadsides across this country? Because of that one small word at the end, okay. Listen to the phrasing again, slowly. Sit tight for me, okay? That tag on the end is doing real legal work, whether the driver realizes it or not. Phrased as a question and answered with a nod, a shrug, or even just silence that the officer chooses to read as agreement, it becomes consent. And consent is the single most powerful tool in this entire equation, because a stop that has already finished its lawful purpose, license checked, ticket printed, business concluded, is, legally speaking, over. From that exact moment, an officer needs one of two things to keep you there any longer. Either new, articulable grounds that meet the Mann threshold, real facts pointing to a real offense, not vibes, or your agreement. Nothing else keeps that clock legitimately running. Your quiet, agreeable, sure, no problem, is doing more legal work in that instant than almost anything else that happens during the entire stop. And it's worth understanding exactly what those extra minutes are often being used for. Dogs come up a lot in these situations, so let's talk about that too. In a case called R versus McKenzie, decided by the Supreme Court in 2013, the court dealt directly with sniffer dogs on the highway. The ruling wasn't that dog sniffs are automatically off limits, they're not. But the police still need reasonable suspicion of a specific offense connected to your vehicle before that dog gets anywhere near it. And critically, they cannot manufacture the time needed to get that dog there simply by dragging out an already finished stop under a vague pretext. Put Mann and McKenzie side by side, and you get the exact same race that quietly plays out on highways from coast to coast. The pen against the leash. If your paperwork finishes and you're released before any new suspicion legitimately develops, and they hold you anyway, that additional detention is arbitrary, full stop, and any evidence that comes from it becomes vulnerable to being thrown out under Section 24 of the Charter. If real, specific, articulable suspicion genuinely develops before your paperwork is finished, that's a different story, and the stop may lawfully extend. Sit tight for me, okay? Is very often how that race gets quietly rigged, buying an officer time for suspicion to show up or for a dog to arrive, using nothing but your own polite, agreeable silence as the fuel. So, what do you actually do about it? Let's go through this properly. 4 rules, and then I'll give you the exact 9 words. Rule 1. Learn to tell the 2 different versions of sit tight apart, because they are not the same thing at all. If the officer is still holding your license and registration and is walking back to his cruiser to run your plate or check for warrants, sit tight at that moment is a completely lawful instruction. That is not a favor he's asking you for. That's the mission of the stop still actively in progress. Comply fully. Keep your hands visible. Stay calm and polite. Do not argue at the roadside. That is not the place to win anything. Those are legitimate minutes on the clock, and the clock is allowed to be running during them. Rule 2. You do not drive away until you have been clearly and explicitly told that you are free to go. I don't care how finished the whole thing feels in your gut, and I don't care how long you've been sitting there. Driving off from a traffic stop before you're released is its own separate criminal matter in this country. Flight from a peace officer. And depending on the province and how it unfolds, that can turn what should have been a strong charter argument in your favor into a genuine criminal charge against you. Sometimes a serious one. Sometimes one that carries real consequences for your license and your record. Your gas pedal is not a legal remedy, no matter how badly it might feel like one in the moment. Your actual remedy is a charter application, months down the road in front of a judge, when the dashcam footage and the body-worn camera footage line up next to each other and show precisely when your ticket was printed and precisely when the extra, unjustified questioning began. Rule 3. And this is the one that trips up more people than anything else on this list. Do not feed the clock yourself. Every extra question you volunteer to answer, where are you headed tonight? Whose car is this? Why do you seem so nervous? Does two jobs for the officer at once. It gives them time they can later point to and justify as still being part of the original stop. And it can hand them the exact, objectively discernible facts that man requires to turn a mere hunch into genuine, reasonable suspicion. Silence. Calm, polite, unbothered silence does not extend a stop under the law. Chatty, nervous answers very often do, and they do it without you even realizing it's happening in the moment. Rule 4. Know your right to remain silent, and know that it applies here too. Beyond identifying yourself and providing your license, registration, and proof of insurance, which you are legally required to produce during a traffic stop, you are not obligated to answer questions about where you're coming from, where you're going, who you were with, or what you were doing. You can be polite and still say nothing. Officer, I'd rather not answer that. Am I free to go? Is a completely lawful sentence, and it costs you nothing. Now, the moment your documents are back in your hand, or they should be back in your hand, and you hear, "Sit tight for me, okay?" Here are your 9 words, and I need you to say them calmly, politely, and, if you possibly can, on camera, whether that's the dash cam already rolling or your own phone recording from the passenger seat. Am I being detained, or am I free to go? That question is a fork in the road with exactly 2 paths leading off it, and nothing in between. If the answer comes back, "You're free to go," then say thank you, wish the officer a safe night, signal, and pull back into traffic. You're done, cleanly, with nothing left hanging over you. If the answer is anything else at all, just hang on a second. We're not quite finished here. Just sit tight. Then you say one more sentence. And then, this part matters just as much as the question itself. You actually stop talking. I do not consent to a search. I do not consent to this stop being extended any further, and I am not going to answer any more questions. Then go quiet. Let the camera keep running. Let the silence do the work. Look closely at what you've just done in that exchange. You have complied completely with every single lawful instruction given to you. Nobody, anywhere, can charge you with obstruction or anything remotely close to it because you did exactly what you were told to do the entire time. And in the process, you have built the cleanest possible record for a defense lawyer to work with later, if it ever comes to that. The lawful purpose of the stop was finished. You asked precisely the right question at precisely the right moment. You clearly withheld your consent, and they held you there anyway without offering any new, lawful reason. From that point forward, every single one of those extra minutes belongs to them, not to you, and every one of those minutes will eventually have to be explained and justified in front of a judge if charges follow. He seemed nervous, something about his demeanor. Explanations like that have a genuinely weak track record once a defense lawyer lays the time-stamped footage next to the man test and walks a judge through it minute by minute. Here's the part about Section 9 that never makes it onto a bumper sticker and that almost nobody driving on our highways tonight actually understands. It isn't a vibe. It isn't a general sense of fairness. It is a real, thoroughly litigated, Supreme Court of Canada tested legal standard, built around whether a detention was arbitrary and around whether a reasonable person standing in your shoes in that exact moment would genuinely have felt free to leave. A test the court sharpened even further in a case called R versus Grant in 2009. And here, in my opinion, is the single least understood fact about driving anywhere in this country. There is exactly one thing that can quietly and completely convert an otherwise unlawful, arbitrary detention into a fully lawful one, without a judge ever hearing a single word about it. Not an officer's gut instinct, not the dog's arrival time. Your consent. Your easy, agreeable, "Sure, no problem, officer," is doing more legal heavy lifting in that instant than almost anything else that happens during the entire stop. And it happens so quietly that most people never even notice they've said it. Police do not need you to be guilty of anything. They need you to be agreeable. Those are 2 completely different things, and the Charter only ever protects you from one of them. So the next time an officer says, "Sit tight for me, okay?" I want you to picture that man on a quiet Winnipeg sidewalk, stopped on nothing more than a loose, generic resemblance to a vague description, whose case traveled all the way to the Supreme Court of Canada and won. You are not going to out-argue a police officer at the side of a dark highway at 11 at night. And I want to be honest with you. Nobody wins that particular conversation in the moment, no matter how well you know the law. What you can do, what actually matters, is making absolutely certain that the record of that stop shows exactly what really happened, minute by minute, and that every single extra minute after your business was genuinely finished belongs clearly and unmistakably to them, not to you. And never, ever be afraid to simply ask the question.